morning. My name is Melissa Schaefer, and I am the Symposium editor for the Journal of Global Justice and Public Policy. I'm also a staff member on the Center for Global Justice, and together we have our annual Spring 2025 Symposium entitled Do Children Have Rights? Thank you so much for being here, and I just wanted to give a rundown of the schedule, and then I'm going to invite Professor Kelsey to come and pray, and then I'll get us started. So, we have from 9 to 9:30, Professor Lynn Marie Combe is going to give us an introduction on the historical and legal context of the Convention of the Rights of the Child. Then we'll start off with panel 1, which is a panel discussion debate on should the U.S. ratify the Convention on the Rights of the Child. We're going to have a break from 10:35 to 10:45, and then we're going to start our second panel from 10:45 to 11:55 on the right to identity, children versus parent versus the state. We're going to have an hour lunch from 12 to 1. And from 1 to 2:30, we're going to have our third panel, Child Protection, Progress, and Challenges. We'll hope you stay for all three panels and get a lot of information and insight from our speakers. Just some brief reminders, please sign in for each panel. There's going to be a different QR code for each panel, and in order to get extra credit, you need to sign in with all three. At this time, I'm going to have Professor Kelsey come and start us off with a prayer.
Good morning. We have a beautiful day today. No snow, so thank you all for joining us for the snow day reschedule. Would you bow your heads with me? Heavenly Father, we thank you for this beautiful space, a gathering of people. Thank you for the opportunity and the freedom to study not only the law, research what is going on legally across the world, but also scripturally, theologically, how we get to approach that and how we get to engage culturally, engage legally, professionally, engage with your heart and with a biblical worldview. Thank you that you set the standard on human value and human life and how we get to see our brothers and sisters around us and how we get to view children, that you define identity, you give us our identity, Lord. So we pray that you would breathe upon just the time today, the research shared, the scholars, and would you be glorified in all that we share? We pray that you would speak to us. We open our hearts and our minds, that we can be shaped by how you view these topics. Would you be glorified in all that we do today? Bless this time. Bless the panelists, those who have traveled. Thank you for the opportunity. We give you all the praise. In your name we pray. Amen.
Thank you, Professor Kelsey. Now I'm going to introduce our opening speaker, Professor Lynn Marie Combe, who, if you are a student, most of you know and love. So Professor Lynn Marie Combe is the John Brown McCarty Professor of Family Law at Regent University School of Law here in Virginia Beach. She has published prolifically on legal areas of concern to families, including marriage, women, children, gender issues, and is a frequent conference and symposium speaker. She teaches family law, juvenile law, bioethics and wills, trusts and estates, and other related courses. Her casebook is Family Law from Multiple Perspectives, published by West Academic in 2024. Her foundational book, Family Manifesto, What Went Wrong with the Moral Base for the Family and How to Restore It, is with W.S. Hine, 2005. And her most popular book is with Olympia Publishing, Estate Planning Success Just for Women, a predecessor of which was nominated for several awards because of its unique perspective on women and their influence over transfer of wealth in the next generation. But her most fun book is Law and Economics in Jane Austen, published by Lexington Books. Prior to teaching, Professor Combe practiced law in New York in the areas of family law, estate planning, probate administration, and real estate. She is licensed to practice law federally in the Northern District of New York, at the Supreme Court of the United States, and in Virginia, New York, Florida, Massachusetts, Washington, D.C., and is a certified guardian ad litem. Please welcome Professor Lynn Marie Combe.
Thank you very much, Alyssa. Alyssa has worked so hard on this symposium, as many of you know. And even though I did not want to cancel it or postpone it, I'm really glad we did. It's a beautiful day and no 11 inches of snow. I gotta say something really quick. When Alyssa read my bio, I'm like, man, I wish there was a UBE when I took the bar exam. So all of you are gonna be waving into several jurisdictions. Yay! You don't have to do what I had to do in many of them, because you didn't know where you were going. At least we didn't know where we were going, but God knew. Okay, so yes, this morning is an honor to be here. Thanks for that lovely introduction, Alyssa. And thanks to all of you for coming. I see a ton of my family law students, so good. So if you guys hear something that I'm not saying correctly, go ahead and correct me. Anyway, good morning. Today, we have the privilege as lawyers to discuss one of my favorite subjects, children. And I think there's even a baby in the back. Where did she go? Where did that little baby go? A little baby boy showed up whose mom is a clerk for Justice Kelsey. Well, anyway, we have two renowned scholars with us. I always like to round up the usual suspects, and so that's who we have today. Professor Stephen Gillis and Professor Jim Dwyer. They're old friends of mine, as you will see. We have been around the block, so it'll be an honor to have them. My job today is to set the tone for what we're going to be discussing today. Then we'll guide our panelists in our discussion, and we're going to have a really stimulating debate, I think. Do children have rights? So in class, all right class, you knew I was going to call on you. In class, whenever any student asks me a question about the rule of law, my answer is generally what? Andrew? Jared? What? Okay, that's Mia's answer, right? The question is, when you have a question, what do you look to first? The code. You always look to the code. Thank you very much. Well done, Bryce. Yes, so whenever there's a question, what does the code say? And you're looking up your code. So when in doubt, look at the code. Today's discussion deals with just 2 areas of code, but 51 areas of law. So they are, first, the Convention on the Rights of the Child. We're going to look at that, we're going to look at its history, we're going to understand it. And then secondly, we're going to look at the state code of 50 states. So those 2 things is all we're going to look at, the state code of 50 states on what, Andrew? Yes, exactly. All right, good. So everything we say beyond those code sections are going to be Supreme Court precedent or analysis or what I would call emerging ideas. So let's begin. We're going to talk about 3 things. The CRC, you're going to get thorough knowledge of that. And then we're going to talk about the best interests of the child and what that really entails. And then we're going to talk about international law and all of this in context. So let's begin by offering that historical and legal context for the Convention on the Rights of the Child. The Convention on the Rights of the Child, which you're going to hear me call it the CRC, opened for signature on November 20th, 1989. It's codified at 1577 UNTS 3, and it was entered into force on September 2nd, 1990. It is an international law treaty. It's designed to protect the best interests of children around the world, and it is held to be the primary instrument known for securing human rights for children internationally, arising out of essentially what I guess I would call American jurisprudence to protect the best interests of the child rather than to protect adults. And it seemed the hopes of children around the world were answered by this wonderful treaty. Indeed, it was wonderful. And it was wonderful to have a standard for the treatment of children in nations where there had previously been a legal void for their protection. There was no protection for children in many nations. In fact, just in my own, as a result of that, as a result of the CRC, a great deal of new research on behalf of children happened. You'll hear a little bit about that. But just in my own career, I participated in several symposium conferences on the CRC at other law schools, at this law Law School. Professor Dwyer was with me in 2006. We were just talking about that. At ALS conferences, in DC with the juvenile justice offices, even in Israel, who is considered a leader on this children's rights area. So we had a 5-day conference at the University of Haifa, and then half of it was at the University of the Hebrew University in Jerusalem. At all these events, nearly every single scholar asserts that the Convention on the Rights of the Child is a result of a widely shared belief that children are especially vulnerable and in need of special attention and treatment from the international community. The CRC is considered as the most successful treaty in international law because it has almost near universal ratification. Indeed, it's been ratified by 192 nations. Do you know how many member nations there are in the UN? 193. The only nation that has not ratified the CRC is the United States. So it's been ratified by everybody but us. So why is that? Hopefully by the end of this panel, you'll understand why. All UN member nations have signed it except the US. And because of that, it's considered the most successful treaty in international law history. It sets out the rights that have to be realized for children to develop their full potential. Indeed, anyone could argue, and I probably will argue, that the near universal ratification of the Convention reflects a global commitment to principles of children's rights. But over the next several years, after its widespread ratification, however, it began to become clear that while some aspects of children's lives were improving, child mortality rates were dropping, child educational opportunities were rising, other aspects of children's lives were harmed or made worse or continued not well, even aggravated, despite the CRC. And if one looked closely enough, it became apparent that there was no longer a battle for children's best interests, but rather the fight became state versus child, or child versus parent, or governments, political powers, adults taking advantage of that vulnerability of people who are now seemingly vested with rights. Children without veritable legal capacity, and most challenging of all those 192 member states had no accountability for holding to the CRC. And a peak of this concern happened in Europe in July of 2007 when the European Commission, or Committee on Crime Problems, the CDPC, met regarding the draft convention on another US treaty proposal, the protection of children against sexual exploitation and sexual abuse. They met to examine the problem of sexual exploitation and abuse of children in Europe. Now this was 2007, just 20 years after the signing. Their report stated, quote, "Compliance with the CRC and its protocols is monitored by the Committee on the Rights of the Child, which has come to the conclusion that children in Europe are not sufficiently protected against sexual exploitation and abuse." Despite the fact that every single nation but the United States has signed the CRC, despite the fact that it's heralded as the most effective human rights document in history, the European community clearly recognized upon a review of the evidence that the CRC was ineffective. It wasn't protecting European kids from sexual harm, it wasn't protecting them from abuse. Rather, the plight of children has, I'm going to argue, worsened. But children have rights. How can this be? And their rights are secured in a treaty. Let me just share with you 6 areas that my research has shown where children are not protected by the CRC. Child labor, child sacrifice, child sex trafficking, child marriage, child soldiers, and FGM. Now I'm going to just say a few words about each of these just to show you how they've changed over the last 30, 40 years of the CRC. Regarding child labor, the latest global estimates indicate that the number of children in child labor has risen to 160 million children worldwide. That's an increase of 8.4 million children just in the last 4 years. These are kids pulled into labor. 63 million girls, 97 million boys were in child labor globally at the beginning of 2020, accounting for almost 1 in 10 children worldwide. 1 out of 10 kids was pulled into child labor. But how can this be? We have a treaty protecting children. Let me say a few words about child sacrifice, because we have some experience with that with our Center for Global Justice. In the early 21st century, several African nations experienced a lot of growth, a lot of economic growth. Uganda was one of those. We have a special relationship with Uganda, with the Center for Global Justice. Uganda has particularly been experiencing a revival in what has become known as the ancient practice of child sacrifice. In fact, a BBC investigation found that ritual killings of children are more common than they thought. The indicators are that politicians and politically connected wealthy businessmen are involved in sacrificing children as a ritual commercial enterprise. What they do is cut off their body parts, bury them where they're going to build their big building, and the child is dramatically harmed, as you can imagine. The Center for Global Justice students, the Region Center for Global Justice students, experience this firsthand, and they work to protect kids against this child sacrifice. In a recent case, the child's ears and nose were cut off, and there were initial charges against a witch doctor that was helping some economic developers. Those were dropped, but then the Center for Global Justice students showed up one summer, reviewed the case was revisited, and the perpetrators were convicted. But Uganda is a CRC signatory nation, and yet kids were still enduring this. The third area is child sex trafficking. This is something that we're more familiar with here because of the Center for Global Justice. Children make up 27% of all human trafficking victims worldwide. They're used for sexual exploitation, for prostitution, for organized crimes. But wait a minute, if you read the CRC, Articles 19 and 34 expressly prohibit the practice against children. In fact, Regent Law Center for Global Justice Fellow Lauren Easton, who I see right here in the front row, there she is, you'll hear from her later. She was working on a case that identified 2 young girls who were criminally charged as prostitutes. Instead, when she started reviewing the case, it became abundantly clear that these girls were human trafficking victims. Lauren's efforts on their behalf resulted in their release from custody and their rescue from trafficking. Wow, yes, exactly, thank you. Yes. But wait a minute, why weren't they protected by the CRC? So let's talk about child marriage for a second. This is expressly prohibited under the CRC, but tragically about 40 million girls worldwide are currently married or in a union. And it's estimated that over the next decade, 150 million girls will be married when they're still girls. Many are not even teenagers, some as young as 3 years old. How can this be? We have a treaty to protect them. And then let's talk about child soldiers. UNICEF estimated that some 300,000 children are involved in more than 30 conflicts worldwide. Child soldiering is still on the rise and really has been on display in the war with Gaza and Israel. You might have seen pictures of children holding weapons, using them in the war. We've seen it in Ukraine-Russia war, where children are getting conscripted off the sidewalks. How can this be, though? Those are all CRC signatory nations, and there's optional protocols even in addition to that against child soldiering. The last area I'll mention is really a hard one to talk about, but it's female genital mutilation, FGM. It is a cruel and horrific form of physical, sexual violence, mutilating private body parts of little girls. Still, it's the custom in many CRC signatory nations, and it's performed on very young girls as a cultural requirement. In fact, it's estimated that 200 million girls and women alive today have undergone some form of FGM, and that's according to the UN itself. All this is happening despite our wonderful treaty of the CRC. Oh, but that's right, we haven't signed it. So now let's turn, with this in our background, knowing this, let's look at that second set of laws, the 50 states of the best interest of the child. And if you're in family law or already taken family law, think about how your state has codified the best interests. That'll be helpful to you. In the United States today, every state has its own codification of the legal standard of the best interest of the child. And it does not do it in a rights framework. It does it in an interests framework, with adults around the child having to uphold that child's best interests. Many state codes even lay out factors for a family court judge to follow in his or her efforts to determine what outcome is in this child's best interests. I argue that the best interest standard is simultaneously the best standard because it considers this individual child on the most local level, but I also argue that it can become the worst standard because it relies so heavily on judicial discretion of a judge who just met the child that morning. But here's the key. If the United States were to ratify the CRC, that treaty would supersede all the laws and rules of every state in the nation on the best interest of the child, effectively sweeping them away to be replaced by the articles of the CRC. And this is largely the key reason why the U.S. has yet to ratify and incorporate the CRC into our laws. Rather, American jurisprudence directs that parents have the rights and the corresponding duties to direct the upbringing of their children. Therefore, barring a showing of abuse or neglect or abandonment by the parent on the child, the parent is presumed to be in the best position to act to protect their child's liberty interests. So indeed, we've covered this in family law that the rule is a fit parent is presumed to be acting in the best interest of their child. The U.S. position is secured by a federal court interpretation of the U.S. Constitution that parents bear these obligations for the care and support of their children, and they do so far better than the state could do it, with more care, not with rights. But economists would call this altruism. Gary Becker at UChicago calls the bond between parent and child an altruistic one. As a Christian, I just call it love. Families are the best, parents are the best to look out for their children. So while the collectivist notion prefers the CRC, like we talked about at the beginning, the primacy of the doctrine of parental rights is characteristic of a constitutional republic like the United States. It's also rooted in ordered liberty and a lengthy history and tradition in the United States and our nation's basing parental authority in Judeo-Christian scripture and tradition as rights and duties older than the Bill of Rights, or as Justice Scalia once said, as inalienable. So in the midst of these current struggles facing families and children that we are going to be dealing with today in the other panels, there's a lot of individualism, a lot of parents' rights, a lot of challenge of children's rights. That can be deeply troubling to scholars like the three of us. And I have three other colleagues, Naomi Kahn, Mary Ziegler, and Maxine Eichner, who've recently written an article called The New Law and Politics of Parental Rights. It was published by the Michigan Law Review. And they present the feminist position on this, that those who protect parental rights are using, quote, parental rights rhetoric for strategic purposes, unquote. They allege that parents are manipulating children. Others assert that the state wants to manipulate children. So which is it? Parents manipulating kids, state manipulating kids, or can children protect their own rights? Now, we can all likely agree that the nation's High Court in Prince v. Massachusetts in 1944 said it accurately when it wrote, "A democratic society rests for its continuance upon the healthy, well-rounded growth of young people into full maturity as citizens, with all that implies." But there is great disagreement between those who wish to protect childhood and its innocence and those who wish to advance rights for children, even if there's no legal capacity for those kids to protect their own best interests. My feminist colleagues make the serious accusation against what they call parental rights politics, that they have termed that what the parents are doing is strategic misdirection, enforcing what they call a strategy of retrenchment by diversion. All this means is that they're charging parents who are seeking to protect their children's best interests as thwarting a civil rights movement for children by using the words they use as evolving strategies used to resist new rights claims for children. However, if you listen to people in the parental rights movement, they say they're sincerely seeking to protect their children's innocence. And many of you in here are parents, and you're thinking of your own kids right now. These parents' rights people say they want to protect innocence as common sense parenting. They want to use wisdom toward trusting a child's decision-making in the context of parental guidance, in the context of that child's personal growth, and in the context of that child's growing maturity into adulthood. These parents' rights folks proffer that the process of respectful parenting keeps the child as the focus for the child's own best interests. There are U.S. and global family law scholars who strongly warn that, quote, a rights framework abandons children to their autonomy. And I have, if you're interested in any of those sources, I have them all cited in my paper. American jurisprudence has held from nearly the very beginning of the nation that there are inalienable rights that no government can take away, and that among those, according to a string of cases from the Supreme Court, are the rights of parents to direct the upbringing of their own children. The corresponding duties to acting in the best interest of those children are also required. Parents have a duty to protect kids, to support kids, to provide for all their needs. This jurisprudence starkly parts ways with previous world history, though, where parents could use kids as slaves, sell them as property, just horrific things. That history was overthrown by American jurisprudence based in Judeo-Christian values. So now, we have the best interest standard. But that's not children's rights. So, indeed, a leading child advocate at NYU, Martin Guggenheim, has spent nearly a lifetime discussing what is wrong with children's rights. And his book is very well known and has been reprinted for decades. With the founding of the United States, then, came a different way of viewing children. And that's manifested in this legal standard used across the country and in every court to this day, the best interest of the child. This, rather than children's rights, is the jurisprudence that has guided American families for almost 250 years. So, children's rights in the U.S. is merely disinformation. What do we need in this debate? We need some clarity. That's why we're here today. This conflict of disinformation regarding the nature of international law and its rights framework versus the American jurisprudence that's guided American families forever. So let me just put now these two sets of codes in an international law context. So let's get a little background on international law. We are here with the Journal of Global Justice and Human Rights. So any discussion of international law has to start with English jurist and utilitarian social reformer Jeremy Bentham. Jeremy Bentham originally coined the term international law in 1789, and that worked to replace the older, what was known as the law of nations. German jurist Lars Oppenheim, in his treatise on the subject, defined international law as, quote, a law between sovereign and equal states based on the common consent of those states. Now, this definition has been largely adopted by international legal scholars, and international law differs from state-based domestic legal systems in that it operates largely through the consent of the member states. So those 192 nation states, member states, consenting to abide by the CRC. International law, therefore, is strikingly different because there is no universally accepted authority, though, to enforce that international treaty upon the member states. They do it only by consent. So for this reason and others, international law has not been without its skeptics. There are few, and they're largely very quiet voices, because that's not cool. But those voices, I'm going to rely on Harvard's Jack Goldsmith and Chicago's Eric Posner. Professor Gillis may also refer to them as well. They say that the dominant idealistic view of international law today is in shambles. And this is from their 2021 article on this. In fact, think about this. You've heard of international human rights, right? Have you heard of international human duties? Hardly ever. That kind of makes a mockery of the rule of law. Rights without duties don't exist. If someone has rights, someone has to have duties correspondingly. Goldsmith and Posner posit that the international law scholarship was an improbable combination of idealism and doctrinalism. And they say that the idealism was reflected in the conviction that international law was powerful and expanding and liberal in orientation. But a tension was created, however, between this idealism and associated state practice and reality. The practice didn't really match the idealistic reality, as we already have demonstrated. And why is that? Well, man tends to fall short in our ideals, don't we? We're fallen by nature. Meanwhile, numerous violations of international law happen. We see them in the news every day. And more frequently, circumventions of the international law reveals the narrowness of the actual commitments to those international laws. Here's what Posner and Goldsmith say. International law can be and often is effective and stable because once cooperation begins, it's in the rational self-interest of states to maintain it. But the relative power of states change, and preferences of states change, leaders of states change, new problems arise, and sometimes on a massive scale. International law may be normatively desirable for the simple reason that it facilitates mutual gains across the states, but it need not be, and here is what they say, and it's their emphasis, not mine. States frequently act in a predatory fashion and can use international law to entrench normatively undesirable outcomes. And that's probably what's happening with those 6 areas I mentioned. Therefore, in the realm of international law, it's necessary to take seriously a few simple facts. Populations are diverse, right? In different nations. Interests across member states are going to be diverse. And no state has a moral obligation to comply with the international law on the basis of global rather than state welfare. They're all going to be looking out for what's best for their state. This is essentially incompatible with commitments to liberal democracy, where everyone works together. On the other hand, I think sometimes our idealism may even smack a bit of colonialism. We're going to tell you the best way to do it, even though we don't do it. Today, many international law scholars, however, have blamed the backlash against international law on populism. And you've seen this in a few countries, not just our own. While there is certainly evidence for that view, neoliberal elements of international law have contributed to this backlash as well. And all this is happening while people in Western countries have lost confidence in their own governments. And they've certainly lost confidence in global governments. This distrust of governments carries over to international institutions. Think of it. The World Trade Organization, the WTO, has lost confidence. The World Health Organization, coming through a pandemic, the WHO has lost a lot of world confidence. And the UN has lost some confidence. All things considered, it's a very rational response. When you're losing confidence in your own government, you're going to lose it in world government. And it's a fact that international law can be expected to change, too, because state interests change, as I've already mentioned. But there's also this growing phenomenon of non-state actors who are not bound by international law, and they are really influencing the international landscape. This is a serious reality. In fact, international law moves unpredictably, might move in cycles. There might be periods of enthusiasm and advance, followed by periods of decay and retrenchment. Beware, this may arise from those non-binding political commitments that really lack legal obligation. It might be gradual, you might not even see it happening, but it's very real. And suddenly it becomes easy to take advantage of the most vulnerable individuals, children. Wow, and children's lives around the planet are really proof of that. So, I have painted a challenging picture, but I hope that you at least now understand the law. I've tried to set the stage with the facts, offering a relatively full view of the landscape, but you should at least now understand international law, how it works with the CRC, and how it works with the best interest of the child. So today, we're here to discuss the horizon. What's on the horizon? We're going to banter these concerns, we're going to lay the foundation for the next two panels, and we're even going to consider what are the current encounters between child versus parent versus state, and what kind of opportunities come out of those, and how do you, as a law student, fit into that? So let's now turn to our expert panel for their commentary and wisdom, and I would like to invite Professor Dwyer and Professor Gillis up here with me. Whether the U.S. should ratify the Convention on the Rights of the Child when children in the U.S. and around the world are not experiencing their best lives. So thank you, gentlemen. Come on up. Let me introduce them to you. Professor Gillis, actually I know them both from other conferences and symposia, so it's really fun getting together again. Stephen Gillis graduated from St. John's. I'm going to make sure I'm reading the right bio. I had a new bio given to me this morning. Okay. Well, first of all, So, Stephen Gillis, my friend, Professor Gillis, joined the Quinnipiac School of Law faculty in 1995. He teaches torts, insurance, administrative law, advanced con law, and law and economics. He graduated from the University of Chicago, so you all have to do law and economics at Chicago. His research interests include tort law, especially negligence and strict liability, and constitutional law, especially parental rights and abortion rights. His recent publications include the Judgment-Proof Society in the Washington and Lee Law Review, and Parental and Grandparental Rights After Troxel versus Granville in the Supreme Court Economic Review. Now this is what's really cool about, that's all very cool about Professor Gillis, but what's really cool about him is before joining the law school, he clerked for Judge Robert Bork, who was the first person canceled when our nation decided there was only one way to think. You couldn't have diverse opinions. Very interesting. And he was a U.S. Supreme Court Justice for Justice Sandra Day O'Connor. Many of us in this room are her fans. So I might have to ask you a question about Sandra Day O'Connor. Anyway, and he practiced also as an appellate litigator, and he taught at the University of Chicago Law before he taught at Quinnipiac. He's married to his lovely wife, Lori, and they have 6 children. Are they all grown up? Do you have any grandchildren?
They're all grown up. We have 5 grandchildren and hoping for more.
Awesome. So we all care about kids. Wait to hear about Jim. Thank you, Professor Gillis. Welcome. We're glad you're here. So now, James Dwyer, joined the faculty at William & Mary in 2000 after teaching law at Chicago Kent and at the University of Wyoming Law Schools. Prior to teaching, Professor Dwyer practiced law with Sutherland, Aspel, and Brennan in Washington, D.C. He also worked in a New York State family court as a law guardian. So I didn't know we had that in common. That's pretty cool. He teaches a wide variety of subjects, including family law, youth law, trust and estates, and law and social justice. Professor Dwyer specializes in and has written many articles on subjects that include family law, children's law, trust and estates, international law. Our bios are echoing each other, Jim. Philosophy of law, con law. But what you don't know about him is, how many children do you have, Jim? 5 children. So we have some good representatives here of parents who have several kids and care about those kids. So would you join me in welcoming Professor Gillis and Professor Dwyer? So each of them are going to give a few minutes of remarks, and then we'll get right into our debate. So, Professor Gillis, would you like to be first? Sorry.
From here, I'm projecting okay? Everybody can hear me fine? Okay, I think I'll just stay here. First, it's a great pleasure to be here, my first time at Regent Law School. So, should the United States ratify the UN Convention on the Rights of the Child? Everyone in this room, I think, would agree we want to use the law, broadly speaking, domestic, international, etc., to protect children from harm and to help them live well. The CRC is an ambitious, aspirational vision for doing so, relying heavily on a set of the rights of the child, and as Professor Cohn mentioned, really drawing heavily on America's family law conceptions and traditions. My remarks right now, in opening remarks, I'm going to address our question by focusing on the interests of the United States and children in the United States. And later on in our discussion, I will perhaps have something to say about whether ratifying the convention by the United States would help children in other countries. But now I'm focusing on the United States. I'm opposed to ratifying the CRC because I think it's a bad fit with our federalist system of limited and divided powers, because I think it would be a misuse of the treaty power, and because the legislation that would be necessary to implement it would, I think, likely have harmful consequences for children and families. Beyond that, even if you disagree with me about all that, and you think that ratifying the CRC would be good for America's children overall, you should consider whether trying to get it ratified is, as I believe, a hopeless cause for the foreseeable future, or whether it's worth investing political capital and organizing and mobilizing on behalf of that objective at the expense of other things you could be doing through law to advance the well-being of children in America. So, put political reality aside for a minute. So assume that the CRC was ratified tomorrow. We woke up, it's been ratified. But it's not self-executing. It's got lots of vague general provisions, but it's not, wouldn't be immediately enforceable domestic federal law. Congress would need to pass laws implementing its many rights-creating provisions. Okay, suppose Congress managed to do that despite all the obstacles to big-ticket federal legislation. The result would be a federal code of children's rights law. In other words, effectively preempting much of family law. The first problem with that is that the 10th Amendment confirms that Congress lacks the power to codify family law. Think of Lopez and Morrison. The second problem is that it's possible that the Supreme Court would conclude, nevertheless, that the treaty power is not limited by the 10th Amendment. I don't think that's what the court would do, but it might. If it did, that would be a hugely dangerous precedent because it would mean that the Senate and the President could actually give the federal government powers that it is not given by the Constitution itself. The third problem is that whether it's constitutional or not, a code of federal child rights would impose a one-size-fits-all regime on our nation, which is a nation of blue, red, and purple states. Our history and tradition have left family law primarily, overwhelmingly, to the states, and for good reason. Different regions of our country have different cultures, different morals, different conceptions of the family and of children's and parents' rights. Imposing one, as it happens, the blue version on the whole country would be bad. So would imposing the red one. Given the regional differences in public opinion and the importance and intensity of people's preferences about the lives of families, parents, and children, letting the people in each state decide, rather than imposing a uniform federal rule, will result in more voters, more people getting the policies they favor. That is better democracy through federalism. If, like me, you're a conservative, you should also oppose ratification because the CRC is likely to result in a substantial contraction of parental rights and a substantial expansion of government's role. The CRC Commission, for example, thinks the CRC outlaws all corporal punishment of children by their parents. Another example, the CRC could easily lead to the conclusion that although private schooling must reluctantly be allowed, thanks to Pierce and Meyer, it should and must be, under the CRC, be heavily regulated with as extensive a federally required curriculum as is constitutionally possible. Those are just two examples. Finally, turning back to political reality. So you're a big fan of the CRC. Here's why I think you should devote your efforts to other children's rights causes, of which, as Professor Coleman and I'm sure Professor Dwyer will attest, there is a huge number. In order to ratify a treaty, the Constitution wisely requires that both the President and 2/3 of the senators present concur. That is a very high bar. The CRC has never come within a country mile of being ratified. No president has even submitted it to the Senate for ratification, even though at least two presidents, Clinton and Obama, said nice things and supported things about the CRC and would have supported ratification if they thought they had a chance of getting the votes in the Senate. This is not a temporary problem. It's not going to go away. The underlying reasons why the Senate will not ratify involve the very problems I have mentioned. The CRC's impact on American family law and the broader ideological and religious divides between Democrats and Republicans, secular and religious interest groups. The CRC's gestalt is progressive, individualist, secular, humanist, and living constitutionalist. That's why social conservatives instinctively, viscerally, and strongly oppose it. The lawmaking it contemplates tends on the whole to empower the government and weaken the family. It is a product of the late 1980s. Here's what we thought, or here's what the State Department folks and the NGOs that put this together thought. The Cold War is over. The end of history has arrived. Liberal democracy and liberal international values are triumphant. And the 10th Amendment was a dead letter. Those dreams have met up with reality in the subsequent 35 years. They're over. And so are these opening remarks.
Thank you very much. So I realize that I'm not going to get your questions unless I get down here and get my phone. But meanwhile, let me reintroduce Professor Dwyer. But Professor Dwyer, can you tell us, you have a new book out about children and migration, right? Yes. Can you tell us about the book while I come back up there?
Okay, well, it addresses every aspect of children's movement internationally to get out of horrible situations and into better ones. I began thinking about international adoption and wrote an article about that, but have broadened my focus since then to other situations of migration, including undocumented minors at borders, international abduction by parents, and just rescuing children from war zones and famine zones and thinking about whether their rights to get out of horrible places might be different from the rights that adults have. So it's a work of philosophy, and I have a flyer with a 30% discount if anybody would like to.
It looked like a fascinating book. I want a flyer, of course. Thank you. Well, so we've heard what Professor Gillis thinks about the CRC, and I'm really glad we can have a free debate here. So thank you, Professor Gillis. Professor Dwyer, tell us what you think. Should the U.S. ratify the CRC?
Well, thanks so much for the invitation, and I'm very pleased by being invited back here. I love the vibe of Regent. It's very welcoming and genuine, intellectually serious, and I thank Alyssa and the Journal for inviting me. So children's rights generally raises many types of questions, legal, philosophical, strategic, so it's been a great field to create a career in. It gives me a lot to write about. I just want to make one general point about rights before we start the day, because there's confusion about it that is a source of some unnecessary disagreement, and that's that rights are not just protections of choices. Many people, when they hear children's rights, think of child liberation and children just doing whatever they want. Rights for all of us also protect interests independently of our choices and are the correlates of duties that anyone owes to children or someone else to further their interests, even if they haven't made any choices about it. You see in the CRC many provisions that are about do these good things for children, not because they asked for it, but just because we who need to exercise judgment for them have decided that it's good. So with respect to the CRC in particular, I have a unique take, which is a nice way of saying no one agrees with me. Makes me feel better. So I come at the CRC as a strong advocate for children's rights, but I see many problems with this convention that other people don't see, and I think ultimately it was a strategic mistake by advocates for children to propose this convention, to take this approach to advancing children's rights in the world. And so the first thing I wrote about international adoption was something called the special rights fallacy, which notes that we generally think if you create a special charter for any group of people, you're making them better off necessarily, right? Why else would you do it? But actually, logically, that doesn't follow, right? You might actually make that group worse off. And there are many ways in which I think the CRC does that. First of all, it makes people forget that children are human, right? So children already had extensive rights under the general human rights treaties, which refer to every person, every human being, without distinction, having a number of negative and positive rights. So negative rights are rights not to be harmed, positive rights to receive certain benefits. And that's been completely forgotten by the child advocacy world internationally. You You ask any question about children's rights in Europe, and people immediately go to the CRC and ignore the International Convention on Civil and Political Rights, which applies to all of us, adults as well as children, and the International Covenant on Economic, Social, and Cultural Rights. Secondly, the CRC begins by announcing a police power approach to child welfare, by which I mean that government bodies are to make decisions about children taking into account the interests of everyone. So it doesn't say the best interests of the child are the standard of decision-making in aspects of children's lives, but rather that children's best interests are a primary consideration, which is very different, right? So the indefinite article, a primary consideration, suggests other interests could also be primary, and also that a lot of secondary interests might override the interest of children. So this is what I call a police power approach, where government acts on behalf of everyone. There's no aspect of children's lives under the covenant that are supposed to be decided solely based on what is best for children. Thirdly, the CRC actually constricts the rights of children in some ways relative to what they had under the General Human Rights Conventions. So the CRC is actually replete with references to other people's rights, which is extraordinary, right? Think of other special rights conventions, like the Convention on Elimination of Discrimination Against Women, Convention on Disabilities. There's no reference to rights of other people, other family members, of the community, and so forth, but the CRC has numerous references to rights of parents, rights of extended family, rights of the community, rights to culture, right? So it's not a very strong statement about children at all, in my view. Thirdly, it fosters sui generis thinking about children. So instead of children's rights being expounded under the general conventions, which have to make their precedents consistent with decisions relating to adults as well, right? So like a general jurisdiction court that's making decisions about many groups of people and having consistent principles that apply in all cases. With the CRC, we just get jurisprudence of sorts by the special baby committee, the Children's Rights Committee, that doesn't need to think about what principles we demand be applied to ourselves as adults, right? So we have this special way of thinking about children that don't have to appeal to general principles. And then relatedly, it relegates children to this other tribunal, so it's not the Human Rights Committee of the United Nations, but the Children's Rights Committee, which is like juvenile court, domestically, just not respected to the same extent as the Human Rights Committee. And then lastly, it makes people think that children have gotten all they deserve, right? There's the convention, you got your convention, we're done, right? There's no more to be said about children's rights. Very little discussion about amending the convention ever since. And that's true with other special rights treaties, right? So now we think disabled people have all the rights that they need, and women have all the rights they need because we've got a convention. And so that's problematic. And international adoption illustrates all of these problems to my mind. So under the International Convention on Civil and Political Rights, every human being has a very strong right to leave a country, right? You need extraordinary justification to block someone from leaving your country, but children trapped in institutions in poor countries who are suffering terribly are under the complete power of their government to just refuse their exit without justification, and no one calls them to account for that. So I would rather see advocates for children push for development of children's rights under general human rights treaties internationally and domestically under the U.S. Constitution and state constitutions, which actually have more to say about children and children's rights than does our federal constitution.
That is a great start, isn't it? So you see the stark difference between our speakers on this panel. And I think there's some common ground as well, which is kind of exciting. That doesn't happen among 3 law professors, not even at Regent, but anyway. Okay, so good, so thank you, Professor Dwyer, very much. So let me ask one kind of It feels like a superficial question, but it's a very good question. Obviously, the United States is the outlier. 193 nations were the only ones that won't sign it. Would signing the treaty give us a better reputation in the international community? Either of you want to start?
I would say maybe and partly. So it's a common way of insulting the United States and the child welfare world to say that we refuse to sign. So it would signal that we want to be team players, that we signaling our respect for children and our desire to listen to what other countries have to say about human rights, including those pertaining to children. But if it doesn't change anything domestically, then it can look cynical, right? So if you look around the world at, you pointed to Uganda, signatories and parties to the convention who flout children's rights pervasively, and their ratification just looks kind of cynical. And if you ask, why was this the most widely adopted convention? Well, one possibility is all the world just saw how noble and morally requisite this convention is, and another is that it required so little and had such weak enforcement attached to it that it costs nations nothing to say, oh yeah, okay, we ratify that.
So you're saying no, not to just be a cool kid?
I think that would not be enough. So people would look at it and say, so what are you actually going to do to make children's lives better?
Okay, good. What do you think, Professor Gillis?
First, my mic's still on. Good. So I agree with Professor Dwyer. I don't think it's. Well, I guess I will add a little bit about international human rights more generally. I think that there is a real tension between conventions like this one and nationalism. And that tension, Professor Cohn talked some about this. And I think that actually it's important for the world, and maybe particularly for Europe, that the United States continue to act like a nation that doesn't care that much about its quote, reputation as it does about its national identity. And that's a short way of saying that when international law gets to the point where it trumps domestic law, as it now does in important parts of the world, for example, rulings by the European Commission can override sovereign acts of the English Parliament. We don't want to go there. And in the long run, that is the goal of the international human rights movement. And I would oppose ratifying the convention to signal that we buy into that movement, because I'm generally skeptical about it.
Okay, good. So, and that might be different than what you would have expected, that it's not about being cool in the international community, rather having integrity, I think is what both of you are saying as well. Okay, so here's a question from the symposium organizers. What weight do American courts, and specifically the United States Supreme Court, look at the international standards for children's rights, especially since we were a big contributor in creating the CRC but never signed it? So let me give you an example. Roper v. Simmons. The Supreme Court there was heavily influenced by international standards and the CRC, and it held that it was unconstitutional to impose a death penalty on juveniles under the age of 18. Very influenced by what I would call emerging trends, thinking in the international community. And since the U.S. Supreme Court gave such great weight to the international opinion in Roper, what does that foretell for the future with the Supreme Court's decisions on children, their standards of what's best for children, etc.? You want to start, Professor Gillis?
Sure. So on this one, I think I'd say I see some downstream risks. For example, the CRC basically says life without parole sentences for juveniles are forbidden, should not be present. So implementing legislation would presumably enact that. And this, if so, the Supreme Court wouldn't have to decide that it's unconstitutional, but even if the U.S. ratified it, sure, some justices would cite the fact that we ratified it as evidence that it's cruel and unusual punishment to sentence a juvenile to life without parole under any circumstances. But frankly, I do think that the justices in Roper and that line of cases, they added this as part of a broad, all things considered inquiry based ultimately on their independent moral judgments about what they think is cruel and unusual. So I do not view it as one of the bigger problems with ratifying the CRC.
So you don't see that the Supreme Court would keep looking to international law as a prevailing method for jurisprudence, or do you?
I think that a Supreme Court that did rely heavily on international law in this way would be a very different Supreme Court than the one we have now, and that this problem with that hypothetical future Supreme Court would not be at the top of my list of why I don't want there to be such a court.
So personnel is policy. Yeah. Okay, good. Well, Professor Dwyer, what do you think?
I think there aren't many other examples of American courts appealing to the CRC or human rights generally. In the marriage equality cases, there might have been some reference to what other nations were doing. But there are certainly opportunities when the CRC could be invoked, corporal punishment cases, for example, but I don't see it. And there's actually material in the CRC that different sides politically, if you will, on various important issues could invoke, say, look, the international community has recognized this. So I mentioned parents' rights. There is also reference to a right to life, and the CRC says that its protections apply before birth as well as after, so that's something that could be invoked by the right to life community. And yet it doesn't happen, I think, because people recognize that it's not going to appeal much to American judges.
So that's an interesting point that you make. The CRC does say that children have a right to life, and it applies to the unborn child as well. And yet, you're right, pro-life speakers don't grab onto that. I don't know if it's because we don't adhere to the CRC, but we don't even make it an argument. You're saying it wouldn't be worth making that an argument because it wouldn't appeal to Americans?
It might be that advocates just don't think of it because the CRC is just not part of our public discourse in the U.S. the way it is in other countries. In Europe, for example, everybody knows about it. It's not just lawyers who are familiar with the CRC. It's talked about a lot publicly. And here it's just not, so I think lawyers don't think to invoke it. And there'd be some risk, right? So if you endorse the document in any way, then you're kind of legitimizing it, and you might not like that in another context.
Okay, good. And for pro-lifers in this audience, just, that's enough, I think, to think about. So we're starting to get your questions as well, which is exciting. So let me start with this first. Oh, there's like 6 of them. Good job, people. All right. Professor Gillis, while one size fits all may not make people happy or fit the local feelings, shouldn't all children be protected equally across the nation?
I don't understand why that doesn't apply to all adults as well.
Adults as well.
And so I guess I would view that as saying, why don't we just dissolve the states and give the federal government the general, Professor Dwyer brought up, the general police power. Let's give it to the federal government. I'm against it. And here again, I agree with Professor Dwyer. Let's think of children as human beings and American citizens. I'm against it for them, just as I'd be against it for us.
Go ahead, Professor Dwyer. Thank you.
I think uniformity per se is not of much value in this context, where decisions are mostly made at the local level. And so if we had a bad law everywhere, I think then we'd be wanting some variety, right? I hope that someplace there would be a good law. And I can think of examples in child welfare legislation. We do have some uniformity. There is actually a federal code, if you will, of child welfare. The federal government conditions a huge stream of funding to states in the child welfare area, foster care in particular, that's conditioned on compliance with certain substantive rules that the states have to enact into their codes if they want to get this money, and it's too much for anyone to refuse. And I could point to some of those mandates and say, that's really good. And I could point to others and say, that's terrible. So the fact that there's uniformities, I like on one hand, but not with the other provisions.
Okay, good. Some of these questions we sort of have touched on, but I think we can reiterate. This next question just says, if the CRC is ratified by the U.S. as a treaty, what effect would it have on the 10th Amendment? I think you both have spoken about that a little bit, but maybe just reiterate what you said and how it would affect the United States. Jim, you want to start?
Right. Well, as Professor Gillis said, the treaty would not be self-executing, so it creates an obligation internationally to do certain things externally, but for any internal changes to happen, Congress would have to act. Also, there are different dimensions to enforcement of a treaty. So simply ratifying the CRC would obligate us to make reports every 5 years to the Children's Rights Committee on what we're doing to comply with the substantive provisions of the covenants, and we would receive a response from the committee about what it thinks is consistent with the convention and what's not. So, but absent ratification also of a protocol to the convention which authorizes complaints against the state party before the CRC committee, there's nothing like a lawsuit that could be brought against the United States for non-compliance. And so with the International Convention on Civil and Political Rights, the sort of adult treaty that actually applies to children as well, we have signed the convention, the covenant, but we haven't signed the optional protocol that allows for complaints, individual complaints against us before the Human Rights Committee. But it would be significant just to submit ourselves, and this is part of the resistance that Americans have, to submit ourselves to an international authority on child welfare and children's rights, and have them tell us, you're doing this right, you're doing that wrong. It's humbling in a way that we don't want to be humbled, I guess.
Yeah, go ahead.
So I'm going to talk a little bit about what I think was the 10th Amendment or constitutional piece of that question. Let me do it by telling you about the Bond case. So the U.S. has ratified the Convention on Chemical Weapons, or the ban on chemical weapons, and they passed, the Congress passed implementing legislation. It defined chemical weapons so broadly that the federal government prosecuted a woman who had basically tried to put some poisonous chemicals in contact with a woman who had had an adulterous affair with her husband. Because under the definition, it was pretty clear that what she was doing was using a chemical weapon. This went to the Supreme Court. And one of the questions was, can the treaty power be used to criminalize at the federal level what amounts to an ordinary assault, right? An ordinary criminal assault. And what the Supreme Court, actually the majority of the court did, was to say, wow, that's a serious constitutional question. We can read the definition in the federal law more narrowly so it doesn't apply to her. Case dismissed. Everybody familiar with the doctrine of constitutional avoidance, right? Okay. The dissenting justices, Scalia, Alito, Thomas, said, first, you're kidding. The law is perfectly clear. It did apply to her. Second, they argued that the 10th Amendment would prohibit the law from applying to her because they said the 10th Amendment restricts the powers of the federal government, and the treaty power cannot be used to give the federal government an additional power over domestic subjects that it doesn't otherwise have. And Alito said, in addition, Thomas said, look, there's also a real question here about the scope of the treaty power itself. The power was designed for compacts between nations they were going to enforce against bloody one another, not about international subjects, international trade, war and peace, alliances and the like, not for aspirational agreements about what rights children should have in my country, your country, and every other country. So those questions have not been answered, but I hope that helps you see why they're there. One more point. It is clear, and you should be aware, that the treaty power, the court has consistently said, could not be used to override anybody's constitutional rights. But the 10th Amendment doesn't deal with rights, it deals with the powers of the federal government.
Very interesting. I feel like we're getting a good overview of all this. Here's the next question, and we've sort of discussed this, but I think we were discussing it prior to the event starting. It seems like there has been a resurgence of this debate on whether to sign the CRC. What do you think is the cause of that? We did mention that to each other. In fact, you mentioned it, Professor Gillis, said about a few years ago under President Obama, it came up. Like, you said they said nice things about it.
There was an organized campaign, an ongoing campaign as of 2006, 2008 to try to make this a high-profile issue. But when I checked on the web, the website was, this has been taken down.
Take it down, okay. What's causing
Right now
this?
is about the worst time to be promoting any kind of international treaty. Human rights treaties are odd because usually we only enter into treaties to solve a collective action problem. Like we have some conflict of interest internationally that needs to be sorted out by an agreement. Human rights are generally not like that. It's like, why do we need other countries far away to be respecting human rights? So, why nations get together to bind each other in a sense on how they treat their own people is kind of a interesting question.
And you both have said, the next question is, what could we do, what could be proposed to expand the rights of children and uniquenesses? I think both of you have said, hey, human rights already does it. Do you want to add anything to that? What else do we need to do to protect children, if not sign the CRC?
Well, as I said, I'd like to see the jurisprudence of children's rights under our federal constitution developed more.
Yes, you've written an article about that, haven't you? A Bill of Rights for Children?
I've written a lot about potential constitutional claims for children under the federal constitution on everything from parentage, deciding who are going to be a child's legal parents at the outset, to corporal punishment, to many other issues, education rights, and child protection after maltreatment. Many of those causes can be looked at through a 14th Amendment lens, due process, or equal protection.
So due process, which is actually going to be largely what people will think. Anyone add anything? Professor Gillis?
Yeah, I'm going to go international for once, contrary to, as I told you, my strong initial skepticism. But what should we do? We should pick an issue like child slavery, right? Which is sexual slavery or labor slavery. Let's pick child slavery. We have experience with slavery. We went there and it was terrible and evil. So let's go to the UN Security Council. And I may get the instruments wrong, all right? So what we want is something with teeth. It's where we're going to have nations that commit in advance to intervening in other nations if they are systematically tolerating, encouraging, promoting child slavery. Now let's see what happens. Let's do something like that about the worst kinds of abuses, right? Where you really could put together, I sound like Woodrow Wilson, right? A league of nations who want to do something about a problem that other nations are refusing to deal with. But you have to be cautious about that. I would not do that, for example, about female genital mutilation or child marriage, because I think there are, much as I wouldn't want any of those things in our society, I think that we have to pick our spots when it comes to the clash of civilizations and the practices that are culturally not just permitted, but have deep roots in particular cultures and societies.
Great points. These are great points all. So I'll just read this question because it follows up. Do you believe if the treaty were revised or amended? I think both of you are saying probably not. We need to do other things. But if it were revised or amended, could it include more specific provisions that address the areas that I mentioned, child labor, child marriage, etc., would it make more people in the U.S. on board with becoming a signatory? Or are there more changes than that that would need to be made? I think you both have made a case that there's probably more changes, but give it a stab. Would there be changes you'd specifically make? Professor Gillis, I think you just said, let's go with specific issues.
I would go with separate actions. I would start with the Security Council, where the power is. The General Assembly can't do anything. It can talk and create documents, but where the power to use force. You need, if you really want something to happen in international affairs, it needs to be backed by the threat of force. It's as simple as that.
So start with the Security Council and say we got to get kids out of this.
Yes, and
slavery.
then go to the General Assembly. That's fine. Let them approve whatever the Security Council nations are willing to back with a real threat of force.
And that's sort of a policy, I don't know, strategy by using people's sentiments. Yes, nobody should be in slavery. Certainly no child should be in slavery. We've got to do something about slavery. That, you're saying, could get an international backing that would be actually teeth to it if it was okay, good. How about Professor Dwyer? You got any thoughts on that?
Some provisions of the CRC are very vague, and as international norms evolve, it might be that those could be given more specificity. I think of labor in particular. I think it just says every state should have some minimum age for employment, and perhaps if a consensus has emerged internationally, then reference to particular types of employment, particular ages might be added. And one particular change that I would like to see is relevant in particular to international adoption, which is to eliminate any language that suggests there should be preference for keeping a child domestically in institutions, as long as that's not really bad. This is how the committee has interpreted Article 21, that the supposed importance of remaining in the country of your birth is more important than being in a family, has resulted in untold hundreds of thousands of children just remaining without parents in institutions, when there are people in America and Europe who would love to welcome these children into their families, and so eliminating any language that could be used as an excuse would be great. And this is actually something that a kind of change that has had mileage in Washington. On both sides of the political divide, the State Department has made some efforts, has been receptive to arguments from advocates for children that it should pressure countries that have shut down their international adoption to reopen and simply try to guard against the worst abuses to the extent they exist.
So there's two areas, adoption and slavery. We could actually target other things. Okay, let me switch gears here with this next question. As an alternative to the rights-focused approach, how can the best interest of the child approach be tweaked to limit the risk of inconsistent judicial influence or cultural norms? You want to start with that, Professor Dwyer?
As you noted, legislatures at the state level try to guide judges' discretion by having long lists of factors that should be considered in child custody and other contexts. States have tried to effect presumptions in some contexts, such that someone who wants to do something different from that expectation has the burden of proof, and that's had varying degrees of success. Ultimately, there's no eliminating discretion, and best interest gets criticized for that reason, but that's life, right? We all make decisions about our own lives based on what we think is in our best interests, and we're not perfect judges, right? We have to exercise discretion. Sometimes we get it wrong. We all make mistakes, and we simply have to hope that judges do the best they can. Unlike us, judges are subject to appeal, right? So there is that safeguard, whereas we just go off and make our mistakes and prejudice ourselves accordingly.
Go ahead.
Well, first I want to give Professor Cohn an opportunity. Should I yield a little bit of my time to you? Because I think when it comes to the best interest of the child standard, you are...
No, they hear from me all the time. They're sick of me. We
All
want to
right.
hear from you.
So then I think what I'll say is, I think Professor Goyer and I have a long-standing disagreement about this one, where I think, if I understand him correctly, he thinks we should be using the best interest of the child as more of an exclusive consideration in some, perhaps in many contexts. I think my vote would be, if you made me the family law czar, not for the whole country, but for, let's say, Virginia, right? I'd say, use the best interest of the family standard. And then you'd say to me, what do you mean family? There's all kinds of families, and I would say, we got to get to work on that. But that is to say the child, of course it should be a primary consideration, as the CRC says. But no child is an island.
Wow, that is different for our policy people coming up next, best interest of the family. I think we got time for one more question here. So it just says, disregarding the federalism problem, what would be the effects of individual states shifting to a rights-based approach? So if an individual state said, oh, we're not going to go with best interest, we're going to go with children's rights. Instead of a best interest approach, if each state individually amended its statutes to meet international standards, how would that change American jurisprudence on children's rights? Would this help avoid the enforcement problems of the CRC? Interesting question. Anybody want to dare? A state dared to do that?
I'd first say that if a state statute says court has an obligation to do what's best for the child in this context, that's equivalent to saying the child has a right. So as Professor Cohn noted, rights and duties are correlates. If someone owes a duty to you, that means you have a right against that person. So it's just different language, and it would punctuate children's situation to use that different language of rights instead of a duty to protect interests. It would certainly be interesting if some state legislature decided that they were going to try to incorporate the CRC committee's jurisprudence, if you will, on children's rights, which they're free to do right in our federal system. So it'd be interesting to try to make them more cognizant of international standards on child welfare issues.
Interesting. I think that's an interesting response, too. Go ahead, Professor Kyle. What do you think? Gillis? I'm going to get your name right at some point.
So, somewhere, Justice William Brennan is smiling at this question, right? Because he wrote an article many years ago saying to the state courts, we're getting in trouble up here. It's not the Warren Court anymore. We can't do as much good stuff with our federal constitution as we used to. Why don't you all jump in and do it? And I'm fine with that article and with this version of it, which is just the let's follow international human rights law. If the New York Court of Appeals wants to start citing the Convention on the Rights of the Child and interpreting New York's law in accordance with that, as a citizen of New York, I'd be troubled, right? But just in terms of those who support those policies, sure. That's part of what's good about federalism. Let New York go down that road, and maybe Virginia would take a very different road. And then we could compare. That's the laboratory of federalism. How are things working out up there in New York?
Well, I think we're about to see how this is going to play out when we look at what California is doing in terms of saying that parents are abusive on certain circumstances. But let's end with this last question here. Why should we care about international children's rights rather than just American children? Why should we care? Because we all do. Or should we just care about American children? I think what both of you have already said is international children are trapped in slavery. International children are trapped in their own countries because they can't be adopted. We do care about children from other countries. We're being baked on the beach here, you guys, by this sunlight, I don't know if you can tell. But why, what can we do as people that understand the limits of rights, the rights approach, to show that we care about children? I think you've already said it. Do you want to make one final statement? Jim, you want to go first?
There's a significant philosophical literature on the extent of our moral obligation or moral perspective. patriotism and nationalism on the one hand versus cosmopolitanism on the other. And probably the best conclusion is some kind of balance of the two. I mean, human beings in general are appropriate objects of our compassion and concern and respect. Yes, I think this journal is about, reflects that kind of concern for people everywhere in the world as human beings. And our national borders don't necessarily define where our moral obligations end. And certainly that's true of children as well. It's harder to translate that into any kind of self-interest. Of course, in the adoption context, there are Americans who would like to care for children, welcome them into their family. So there is that self-interest that maybe why the State Department reacts positively. But I guess it's a personal question ultimately, whether you think you have an obligation to care about what's happening to a child in an orphanage in Kazakhstan, or only about children in Virginia Beach.
Thank you. Professor Gillis?
Well, I think I agree it's a moral question. It's a religious question, right? And for anyone who subscribes to one of the Abrahamic faiths, each of which I think says each human being is created in the image and likeness of the Creator, there's pretty clear consequences in terms of caring for the other. And international human rights, though it's not religious, right, it can be the driver for non-religious people of similar universalized sentiments. We should respect the human rights of everyone everywhere in the world, because as free and autonomous individuals, that's what we want for ourselves, right? That's not a religious argument, that's a Kantian one. But there it is, it's there. And so there's huge amounts of common ground, but there are limits to that common ground.
And just to wrap all this up, I would say too, there are things you guys can do. Write your student note on something that you're really burdened by, that you feel God is compelling you to write about, research about it. Go there, do something. This is what has always motivated missionaries, to go to needy places. So there are things you can do. Going there, staying here, and you can do it while you're in law school too. And I'll just kind of wrap up our panel today by saying what we've been discussing is the whole rights approach to dealing with very vulnerable people who are going to always be dependent upon some adult to enforce their rights. And that's just a dangerous place for children to be without someone that really cares about them and knows them. So would you join me in thanking our panelists? We have a little break, right, Alyssa? Okay, we have a break for until 10:45. So go ahead and get yourself some drinks. Anything else you want me to tell them?
Remember to sign in.
Sign in. You want to get your credit. Thank you.